Subscribe to our YouTube channel and press the bell icon to get the latest updates.
Over the past so many weeks, we've all got so used to action-packed issues being discussed on CutTheClutter, Afghanistan, Taliban, stuff happening in the Middle East, stuff happening in China, between China and Hong Kong, so on and so forth, and always our domestic Indian politics. That is the most action-packed of all. That what we are going to talk about today, I promise you, you will find deadly boring. But let me also tell you at the same time that it's deadly important as well, because a first-rate confrontation is now developed between our higher judiciary, that is the Supreme Court, and the executive, which is Government of India. And this is Modi government with a full majority, etc., etc. It can pass what law it wants in Parliament. And it has done so with one particular law or one particular set of rules and decisions repeatedly so. Supreme Court has been striking it down repeatedly, and now it's come to a stage where Supreme Court Chief Justice himself has sort of issued an ultimatum to the government. This is over the rules and laws governing India's tribunals. Tribunals were set up, they are provided for under the Constitution. They were set up to speed up our really slow judicial process. On the other hand, now government and the court, Supreme Court, have been fighting over how to appoint members to the tribunal, who will choose them, what will their tenure be, what will their salary and allowance be, what will they do, etc., etc. In the process, a lot of these tribunals are now at a standstill, or they function very little. This includes some of the more familiar tribunals like Income Tax Appellate Tribunal or Armed Forces Tribunal, Central Administrative Tribunal for Civil Services, Armed Forces Tribunal is for Defense Services officers for their grievances, and income tax consults a lot of people, all taxpayers. So a lot of those tribunals are functioning at very little strength, and the cases are piling up there. So that is an issue on which we'll talk about in a little bit of detail. I promise to keep it short and sweet because I know it is very cluttered and very complicated, but it is important. So before I get started with this Supreme Court versus Modi government issue, let me also tell you a story. And this story comes up in the context of something that's actually happening in Afghanistan with the Taliban. So what's happening there is Taliban have now declared quite firmly that one thing they will not allow is music. So they will allow some kinds of music, that is religious chanting but without instruments, like Naat singing, which is religious Islamic singing. That you can do, but without any instruments, no dhol, no baja, nothing. You can do it, but purely devotional chanting like that, no other music. So much so that the Afghan women's orchestra members have now gone overseas and sought asylum there. Taliban have gone to the music academy in Kabul and broken all the instruments there. And you see those pictures, those are quite heartbreaking. And in interview after interview, Taliban spokesmen have said, and in this case, I have no hesitation using spokesman. I don't have to say spokesperson, because the Taliban do not think that women should be in any position of power or they should speak on anything on their behalf. That's why they have an all-male government. So they've all said they don't support music, they don't like music, they banned music. In fact, even on their FM stations, they've stopped the airing of any music whatsoever. So this has become a country of nearly 4 crore people who are completely deprived of music now. Now, is music un-Islamic? So that is a debate, and that's a question that keeps coming up. So in the really conservative world, the one side of conservative world, some people insist that it is un-Islamic. Music is un-Islamic. So this question had also come up with Ustad Bismillah Khan, because some clergy members somewhere in the Middle East had said that the music that he plays is un-Islamic, and being a Muslim, he should not do it. In the summer of 2005, I went to Varanasi to record a Walk the Talk interview with Ustad Bismillah Khan. We recorded on the terrace of his old house on a street named after him. The street was called Bharat Ratna Ustad Bismillah Khan Marg. On the terrace, it was a slightly drizzly day. he lay on his bed or in full recline as usual with his Shehnai on the side, and I asked him the same question about the Maulvis who said that music is un-Islamic, and he said, मेरा उनको एक जवाब है जो मैंने उनको दिया, आपको भी बताता हूँ, that I have an answer to them. I gave an answer to them which I will repeat to you. The answer is that what happens when the you Maulvis give a call for namaz. When you call the faithful for namaz, you climb on top of the masjid and then you call out the faithful at namaz timings, at the correct timing, and say, now this is the time for this namaz, gather together. Now, isn't that call made musically, the azan, or do you get up on top of the mosque and say, hey, all of you, faithful, come, this is the time to pray? You don't say that. And he then said that I tell this clergy or these conservatives in my faith who say that music is un-Islamic, that if you speak non-musically, even Allah won't listen to you. Even God won't listen to you. Even to pray to God, to make a call for azan, you have to say it musically. So how can Islam be against music? So I just thought, I remembered this because this controversy again came up with the Taliban, and I thought it was interesting. And I will also tell you that many of you keep writing to me that when I am recording, in the background, you hear the azan. Now, there is a mosque right across this road from where I work. I worked in this building for 26 years, since 1995. And I have heard this azan at fixed hours of the day as and when it's scheduled. And I'm quite used to it, and frankly, I quite like it. I find it soothing. I don't understand what is being said, but I find it soothing. Also because this is spoken musically, in a good voice, in a devout voice. So I don't know why anybody, I see some people saying that I should buy a soundproof glass, etc., etc. I would say, let's not go there. You know, people pray, people of all faiths pray, and as long as they do it in a soothing manner, in a musical manner, it's fine. Because if we start objecting to things like that, that will be the same as, say, the one section of the Islamic clergy saying that music is a bad thing. Now, back to our more serious topic. So what's happened in the Supreme Court is, this Monday, a powerful bench of the Supreme Court, headed by the CJI and V. Ramana himself, also Justice Chandrachud and Justice Ellen Rao, all three of them sat on that bench and they got really angry. And they said government has no respect for the Supreme Court orders. It's testing the patience of the court. Why did they get so angry? They got so angry because there's been a history that's gone on in the tribunals now for 4 years. In 2017, with the finance bill, that's the budget, Modi government came up with some sweeping changes on the tribunals, on the way tribunals function. Usually, each tribunal has an act, individual act backing it. For example, National Green Tribunal has an act backing it. Income Tax Appellate Tribunal has an act backing it. Prevention of Money Laundering Act Tribunal has a specific act backing it. But with this budget, government gave itself sweeping powers to make changes in the functioning of the tribunals. These changes were about appointments, about tenure of the members, about who the members should be, the qualifications, their pay and allowances, whether they will get a house or not, whether they will get HRA or not. But those things were not so important as the fact that it looked like government was taking over all these sweeping powers of appointing these members. So first of all, and this is now an ongoing tussle, this has happened 4 times. When the 2007 issue came up, then issue came to Supreme Court. Supreme Court struck it down. Supreme Court said this is not correct, you cannot do this. As the Supreme Court did that, the government yet again repeated that. In 2020, Supreme Court again struck it down. As it struck it down, Government of India again came with an ordinance in April of 2021 saying the same things. Supreme Court again struck it down saying that this is not correct, you cannot do this. And now the government has passed this new law, the new act, which is saying exactly what the Supreme Court has struck down repeatedly. So Supreme Court is now saying that you have no respect for what we say. Either And Supreme Court has said that we acknowledge that Nirmala Sitharaman, the finance minister, said in Parliament that legislature has the prerogative to make the law. The court cannot make the law, judiciary can't make the law. So the judges have said, all right, we are not questioning the legislature's right to make the law, but if your law is completely violative of our orders, our recent orders, and several benches, constitution benches have given similar orders, then at least tell us, show us the debate, show us the argument where you have questioned and you have dismissed or rejected the basis of our judgment and our orders. You can't just do it arbitrarily, that okay, we have the power, so let the court say whatever the court is saying. You have to give us the reason and you have to explain it, and you have to then justify overriding everything that we have been saying. In the process, what has happened is, this is not just a territory issue. There's a turf and territory issue here. But the larger question also is that many of these tribunals have now had vacancies for years. You see, Armed Forces Tribunal, people are waiting for their cases. And it's very difficult to get tribunals together. Income Tax Appellate Tribunal, there are so many cases there. So usually, because a lot of the hearings are virtual, people say, एक member is bench से लिया, एक member उस bench से लिया, एक member उस bench से लिया, so somehow put them together. But the cases are piling up. And as the cases are piling up, now people, litigants, are going to Supreme Court. So Supreme Court said the whole point of setting up the tribunals was to reduce the burden of higher judiciary. And now, because government is sitting on the appointment of members of these tribunals, and most of these tribunals have humongous vacancies. These are 19 tribunals. The new law has reduced them to 15. 4 tribunals have been abolished under the new law if the law sustains. But government has not cleared any appointment. So once again, the judges said that there are more than 100 appointments cleared by this election committee which are sitting with the government, as the government is not clearing them. And these appointments were made under a law as existed, so government can't retrospectively now say that new laws will apply or new rules will apply. I am oversimplifying it as usual because I don't want to go into the minutiae of the law. Now, what's happened is this selection process. Selection is done by a committee which has its principal set, how many members, etc., etc. The committee is always headed by a Supreme Court judge nominated by the Chief Justice of India. So this committee has chosen these members. Government under the new law, and even before that, twice when they framed new rules, after the changes in the Finance Act in 2017 and also in the ordinance, government repeatedly keeps bringing the same thing. That one, this committee, they will have the right to appoint more members to this committee. That means more administrative members, more bureaucrats, essentially, so that the executive has greater say in who's appointed. And even then they say the selection committee cannot send them one name to be selected. It has to send them 2 or 3 names, and government will then pick one of those, which means once again the powers of the independent selection committee are being completely curtailed. Now that is something that the judges do not like, because these tribunals look at very important issues. They look at these are quasi-judicial. They record evidence which is then admissible in court later, in Supreme Court. They look at taxes, service matters, administrative decisions, environmental issues, and company laws. So in fact, the judges, when they got angry, also said that look at tribunals like NCLT, National Company Law Tribunal, or NCLAT, National Company Law Appellate Tribunal. These tribunals are the very cornerstone of India's economy right now. You know what? Because one of the reasons is that India's entire bankruptcy process goes through these tribunals, and they are short of members everywhere. So Supreme Court is saying, how can you go on like this? And they have then threatened the government. They've issued, maybe threatened is wrong usage from me. They have now given a kind of ultimatum to the government. They've said we can do one of 3 things. One, stay the act, which you've just passed in August in Parliament. Stay the act and direct the government to make these appointments where we have selected these candidates. They are waiting for more than a year. More than 100 candidates selected are waiting for more than a year to year and a half. That means in this year and a half, more vacancies have come up in these tribunals. It's a mess. So one, we stay the act and direct you, the government, to make these appointments, right? Two, that we invoke powers under the constitution that the Supreme Court has, and to make these appointments anyway, whether the government likes it or not. So override the government. We have the powers under the constitution, use those powers and do it. And number three, they say we might, if we don't do the two of these, then we might even have to initiate contempt proceedings against the government. Now, government, it looks like, has dug its heels in and they don't want to give in. And that's the reason I say it looks like a very strong confrontation is now building. So I will also tell you the 4 tribunals that the government has abolished. And you will find some interesting stuff there. Number 1, Airport Appellate Tribunal. I don't understand exactly the implications of it. Second, Authority on Advanced Rulings. If it's to do with tax, I do understand that some parts of it or some aspects of it are a bit superfluous, because even when the authority gives you an advanced ruling, it's not binding later in a court of law or even in an appellate tribunal, tax tribunal, if it's that. Third, Intellectual Property Right Appellate Board. Now you go to High Court straight, not to the Appellate Board. And fourth, very important, Film Certification Appellate Tribunal. That means if censors reject your film or censors ask for cuts that you don't like, then now you can't go to the tribunal, which can decide probably faster. You have to go to a high court, and high court, then you're in the queue behind all the bail applications and all other issues that keep coming up all the time. So the very purpose for which tribunals were set up then gets defeated. Now, as you go into the details of the debate between the Supreme Court and the central government, you also understand and learn new things. For example, these tribunals, unlike your normal Supreme Court judge, also has space for specialists. For example, each tribunal has a judicial member. Usually the judicial member heads it so that the tribunal is impartial. But the government, with the new changes, now wants the freedom to also have administrative members heading it. Administrative members are usually retired civil servants. So it's also civil service versus the judiciary tussle in terms of turf. The second thing is that this has qualified people in their specific fields. Now, government, that usually comes in through the selection of practicing lawyers in that field. Intellectual property, for example. Now, what the government has said repeatedly in the changes they make, for the lawyer member, they say minimum age should be 50. So once again, the Supreme Court said that if you say the minimum age is 50, that means the lawyer member will always be a much older person. And many of the issues that are coming up are technical issues. They are issues that older people are not familiar with. And they say that we judges are not familiar with. So this will bar younger, better informed lawyers from becoming members. So Supreme Court just said, keep the minimum qualification of 10 years experience, but don't put minimum age, because the moment you put minimum age, you are excluding a lot of people, lot of good lawyers, good minds who may be better qualified to talk about these issues than people who are more senior or people who are more older, because technology, etc., changes all the time very fast. So all this tamasha is now going on. Let us see what the government comes back with, because there are lots of issues pending. Now, before I conclude, one more observation I see often from some of you who take umbrage at my using the word something having sex appeal. For example, I said yesterday the rise in edible oil prices does not have the same sex appeal as the rise in the price of onions, or this issue is not sexy. And some of you say, why do you use the word sex or sexy there? Why can't you just say more interesting or more something? Now, first of all, to call something sexy or to say something as sex appeal doesn't necessarily have to do something with sex or something which is erotic. In fact, I'm sharing with you this page from the Merriam-Webster dictionary for evidence that this is now a common usage for something that is interesting, that is engaging, or that is attractive, right? It doesn't have to be erotic. Erotic is the old-fashioned meaning. So this expression is now freely used in polite company and is fully publishable. So for heaven's sake, let's not be prudish for the heck of it, unless we want to be like the Taliban.